Hello there and welcome to the Employment Law Show. Once again, we're back. You're back. We're ready to fill your head with useful information. We're going to go through the weedy, murky laws of employment law and workplace rights. Can be a confusing landscape, but that's why we do the show every week, to clear it up and make sense of it all. John Scholes here, and as always, Lior Samfiru, employment lawyer at employmentlawyer.ca. Always tell you off the top to reach out to Lior with any concerns. Do not Google. Do not go to your neighbor. Don't trust Steve. Always go to the source properly, 1-855-821-5900, help at employmentlawyer.ca. And for any other matters, there is a website that was created a few years ago, super handy. It's called pocketemploymentlawyer.ca. We'll put that to some use here in just a bit on the show, so don't fear that. Main topic always on the show in the second segment. This week, lost your job, 5 things you must do immediately. Super important stuff. We will get to that and so much more with some phone calls, viewer phone calls as well. But a busy show, Lior, so let's tuck in and get it done. Week that was, what do you got to crack it open with this week?
Well, John, really good to be talking about employment law again and to try to demystify and help as many people as possible. I'm so proud of the fact that every week we have people watching the show, and every week more and more people are watching because they heard that this is the place, this is the time where you get answers about your workplace issues. You get some solutions, some help, things that you can't otherwise understand or figure out. We're not going to lecture you about complicated things. We're going to tell you what you need to know in your everyday workplace life, whether you're dealing with a bad boss that's making your life difficult unnecessarily, whether you're being mistreated, harassed, or bullied, discriminated against, if you've lost your job, if your job has changed, you name it. If it's an important topic that deals with work, we cover it. We tell you what you need to know. But of course, this is a 30-minute show. It's going to be over before you know it. Good news is we're not going anywhere. You can reach me and my team off air so we can have a more in-depth discussion so that I can roll up my sleeves and get to work and actually help you resolve those workplace issues. So great starting point right here on the show to make sure that the job is done fully. After the show, we'll give you that contact information. But enough of that. Case of the day, where I always like to start off, a situation that came across my desk very, very recently. I spoke with a gentleman that a few months ago had actually taken a loan from his employer. Employer loaned him some money, nice employer. He needed some financial help, and they had an agreement that he was going to pay that over time. Well, very recently, that employee decided that he's leaving. He's resigning his job to go find another position. And when he resigned, his employer said, well, you owe us this money on account of the loan, so we're going to take money off your final pay in order to reimburse ourselves for the money that you owe us. He was concerned about that because he needed that last pay to pay his bills. So he called me with a very simple question, which was, is my employer allowed to deduct from my pay the money that I owe them? Well, the answer to that is very straightforward, and the answer is no. The employer is not allowed to deduct from money that they owe you the amounts that you owe them. He owes this money. Let's be very clear. There's no mystery here. There's no doubt that he owes his employer money. But that salary that he's owed, that pay that he's owed, is sacred. The employer is not allowed to deduct from that, even if the employer is owed money. Now, that employer could, if they don't get paid, they could take legal action to pursue amounts owing, but they're not allowed to deduct from pay. So I wanted to remind everyone here, because this is something that comes up very often. Employers say, yeah, sure, we'll give you your pay, but you owe us this amount of money. Maybe you're overdrawn on vacation, or there's other amounts owing to us. We'll take it out of your pay. Unless you agree to it in writing, they're not allowed to do that. Again, that pay is sacred. No one should reduce that pay. You should get paid your full amount, even if there's amounts owing to your employer. If your employer won't do that, if your employer is reducing your pay or taking amounts off your pay without your written approval, I want you to call me right away.
First of all, smart employee, because most people would think, yeah, that makes sense. You borrow the money from them, you're leaving, you're walking out the door. Of course you pay them back out of your pay, so smart for them to do that. How far does that go as far as not being able to go to your employee to get money back? Oh, you crash a company vehicle, you break a company computer, we'll just take it out of your pay next time. I mean, where's the threshold, or is there any threshold for that?
Well, it's a great question. Now, in this particular case, he owed the money, right? Because he was lent money. The employer didn't have to lend the money. They lent the money, and he had to pay it back. But there are situations where you may think you owe your employer money, but you don't actually owe it. And John just gave a great example. Let's say during the course of your employment, you damaged the company vehicle. It's an accident. The company now has to pay maybe their deductible. They have to pay a couple $1,000s to fix the vehicle. And they say, well, we're going to take it off your pay. They can't, not just because they're not allowed to reduce your pay, but also because you actually don't owe that money. If in the course of employment you do something that causes your employer financial loss, as long as it's in the course of employment, it's kind of the cost of doing business for your employer. They're not allowed to take that off your pay to make you pay for it. Now, if you decided to take the car for a joyride, not working, and then you cause damage, well, that's, of course, a very different situation. You're not in the course of employment. But the general rule is this: if you do something that causes your employer financial loss during the course of your employment, doing your job in good faith, they can't make you pay for that. It's just the cost of doing business.
So if you take it one step further, say, okay, you don't have to owe them for the damage to the car, the deductible, whatever. Can you be let go for cause for that particular infraction? Because that's obviously happened before, right?
So if you are negligent and you do a bad job and you cause losses, yeah, potentially you could be let go. But if it's an accident, I'm not that I was doing this deliberately, it was just an accident, you probably cannot be let go for cause. The fact that you did something wrong, the fact that you may have done something that caused your employer damages, money, does not mean you can be let go for cause. It doesn't mean you deserve the worst penalty. So that's how high that threshold is for a termination for cause.
They would have to pay your severance.
Full severance, that could be as much as 24 months pay.
Again, reaching out anytime to Lior is simple, 1-855-821-5900 and help@employmentlawyer.ca. Want to get to our first phone call from one of our viewers here right now, so listen up and we'll dive into that a little further as well.
Calling to find out about my wife's situation. Her position got terminated after 22 years of work in the same company. She's being offered a package, which is 8 weeks notice, plus I believe 9 months of continuous pay. Or the other option is just similar position, whatever she had, but only part-time.
Can you tell me what her position is and what her age is?
She was a library technician at a private school, 58.
That's an interesting, offer. Full-time, you're gone, but part-time will keep you around. It's interesting.
Well, let's start with that then. Let's start with that part-time offer. So certainly an employer is not allowed to make you take a part-time job if you're already working full-time. That's a significant change in terms of employment, and an employer cannot do that. So right off the bat, this becomes ultimately a termination. They're letting her go, so severance has to be paid. So really what we need to assess here is whether the severance offered here, which is 11 months, is appropriate. Now, what they're doing is they're offering a couple of months' notice, and they're going to pay the rest as severance. So for a total of about 11 months. We need to know if it's appropriate. Spoiler alert, it's not. But let me show you how you can find out yourself. So we're going to use our severance calculator tool. You've heard me talk about it before. You can find that at pocketemploymentlawyer.ca. Let's use that right now, and let's see what the right amount of severance is. So we know that this person is a library technician. She's been there for 22 years. That's a long time. Her employer says, yeah, we're going to give you 11 months. Nonsense. That's a wrongful dismissal because, as you can see in the bottom there, she's owed 18 to 22 months. So essentially double what she's been offered. So that's why we use the severance calculator. That's why you need to use it. pocketemploymentlawyer.ca. It's free and anonymous. Anytime you want to understand your legal entitlements on termination, you have to check it out.
That's another perfect example where someone might think, oh, they're just a library tech. They don't qualify for any more severance than that. It doesn't matter. It's 20, she's got a lot of years in, right?
Oh yeah, and the biggest factor, of course, is length of employment. But yeah, definitely, and certainly age is a factor as well. But the reason why we need to use that calculator is it's not a straight assessment. I work this much, so I get that amount of severance. No, there's many factors. The severance calculator uses them to assess those entitlements. You'll be surprised by how much you're owed, probably much more than you realize. So again, pocketemploymentlawyer.ca.
That is phone call number 1. Thank you very much. We always do 2 in a row before we break, so let's get to that second phone call now.
I'm just coming back from maternity leave, and it was remote for a year, and my employer wants me to go back into the office. I'm just wondering if I have any grounds to push back on that.
Working remotely only for the last year before your leave?
The position was created a year ago. I worked it remote for the entirety of its existence.
You took on this role knowing that it's a remote role?
Yes.
This one's what they call a no-brainer.
Yeah, no, it's certainly a no-brainer. So there's 2 things we need to kind of assess here. Number one is the parental leave, maternity leave issue. So if she's coming back for parental leave, her employer has the obligation to put her back in the same job she had before, and clearly before she had a remote job. Now, if this is a major change and everyone that used to work remotely is going back to the office, maybe that's something that is okay, subject to what I'm about to tell you. But if she was working remotely and she was the only one and now they want to change that, they can't, because they have to bring her back after parental leave to the same job that she had. But even if we forget about this parental leave situation and we simply look at a matter where someone works remotely and then the employer says, yeah, that's going to end, we want you to come into the office. What does that mean? In most cases, your employer is not allowed to do that. Why? Because working remotely is a significant and an important term of employment, and your employer can't just change that. So it's not allowed. But if you say no to your employer, I'm not coming in, one of two things will happen. Either your employer is going to back off, fine, okay, stay remotely, no problem, or they'll let you go. Keep in mind, your employer can let you go pretty much for any reason as long as severance is paid. So they would have to pay full severance. What they cannot do is say, because you didn't come into the office, you've resigned, or we can let you go without severance. That's illegal. Could you potentially lose your job with severance? Yes. So before you make any decision, if your employer is asking you to come work in the office, let's talk about it so that you understand what's at stake, what you're owed, and we can talk about the best way to approach it.
It's interesting, too, because it's almost like the extra layer on this one is the fact that not only had she always worked remotely, but now she's got a newborn at home. So it's even more important, you'd think, in essence, for her to be home and work from home with a newborn, with a new child.
Well, we can add a layer to that, absolutely. If, for example, because of her child, she needs to work remotely because there's no other childcare available, then now we're dealing with a human rights issue, potentially. They need to accommodate her by allowing her to work remotely. So there's definitely a lot of layers here, which is why, John, so important not to do anything before we speak.
And we will take a short break in our main topic and third phone call on the other side, so stay with us. Plenty still to go on the Employment Law Show. Don't go anywhere. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back to the Employment Law Show. John Scholes here. As always, Lior Samfiru, reachable at employmentlawyer.ca. You want to email him, just put help at in front of that, help at employmentlawyer.ca. Phone call as well, 1-855-821-5900 anytime, so reach out. Our third phone call of the show is coming up right now that we're going to lead into our main topic, so let's have a listen to that third one. Here we go.
I was terminated and I was on a contract role for 1 year. I was only with the company for a few months, let's say 3 months. And however, once I was terminated, I did not receive any severance. So I guess my main question is, even though as an employee in a contract role, would someone be owed severance package?
You already know my follow-up question after all this, but break it down for us. How's it work?
So this is what we call a fixed-term contract. So you work for a specific and defined period of time, a year in this case. It could be 2 years, it could be 3 years, whatever it is, defined period of time. Well, the general rule is this. If you are let go before that contract comes to an end, in this case, it's 3 months into a 12-month contract, your employer has to pay you the balance. They have to pay you the difference. So in this case, another 9 months' pay. So yeah, you work for 3 months. They want to let you go, they can, but they have to pay you for those last 9 months. So that's the rule. And I've had cases where someone had a 5-year contract and was let go a few months into it. Well, guess what? The employer had to pay that difference. So definitely important. If you're let go in a fixed-term contract before that end date, let's talk. You may be shocked by how much you're owed.
And what's the question I'm about to ask you?
Go ahead, John. I'm not
Why
going to
do you bother signing people to contracts in case that happens, right?
It makes no sense. For most employers, in most cases, to have a fixed-term contract, it's pointless. You can have an indefinite contract with a termination clause that allows you to let someone go at some point if you want to. You get into unnecessary trouble and complications with the fixed-term contracts. But hey, I'm not going to stop employers from doing that if they want to. It just means that my clients have more entitlements.
You got it. All right, main topic time, as I mentioned off the top of the show, you've lost your job. 5 things you must do immediately. Or number 1 is avoid the pressure to sign something immediately, right then and there.
Yeah, and that is a massive one. So every termination letter, severance offer, whatever you want to call it, severance package, has a deadline. So here's what we're offering you, but we need you to sign this by Tuesday, by Friday. We're going to give you this specific deadline. Oh, and by the way, bad things are going to happen if you don't sign. We're not going to pay it to you. Well, for most people, that's quite shocking and scary. I lost my job. Oh my gosh, I need to pay my bills. So I better accept this or I'm not going to get paid. I'm not going to have any money. Guess what? It's a pressure tactic. You cannot do that. You cannot sign that offer. Think about it. The only reason they're putting pressure on you is because they know that they gave you a bad offer. And they want you to accept it so that they can get away with paying you less than what you're owed. Don't let that happen. It's a pressure tactic. You have 2 years from the date of termination to pursue your entitlements. Nothing happens on that deadline. You want to help you be nice to your employer, ask for an extension. You don't even need to do that. Let's make sure you get what you're owed. It's a pressure tactic. Don't fall for it. If you do fall for it, if you sign it and then realize you made a mistake, it's likely too late to do anything about it. So please, that pressure tactic, avoid it, ignore it. Let's talk.
Again, lost your job, 5 things you need to do. Number 2 is the housekeeping part, right? You got to gather your paperwork, employment contracts, termination letter, performance reviews if they're around as well, right?
Yeah, so documents are important. It's time to assess what you're owed and assess how we are going to get you what you're owed. We need to look at a few things like your employment agreement, job offer letters, performance reviews if there's performance allegations. I'd love to look at a bonus plan to assess what and how much of the bonus you're owed. Those are important documents. Now, could you move forward without them? Yes, you're better off having those documents. So take the time, maybe where you still have access to your work email, get those important documents, ask HR for them if you don't have them. They'll give them to you. It's not a problem. And then once you have that, we need to talk with those documents. It's going to make life that much easier.
Even if you even had an employment contract to start, right?
Well, if you don't, consider yourself lucky. That's a great thing. We'll talk about that another time. You don't want that employment agreement, but if you have one, if you sign one, whether it was when you started working or at some point later on, very important that we see it.
Job number 3 for you is this: question the for-cause claims, because they come in super fast and heavy.
So here's what I mean by that. If your employer is letting you go because of without cause reasons, restructuring, cutting costs, they're probably not going to answer too many questions about why and why you're cutting costs and, is that really what you're doing? They're not going to go there. But if they're alleging cause, in other words, they're saying you've done something so wrong that they can let you go for cause without severance, well, at that point, they will answer questions. You need to find out what it is that they're saying you've done, when you did it, what proof do they have of that. Ask those questions, get that information, okay, so that we can fight that properly, so we can assess whether or not they have cause. In most cases, this is very important, John, in most cases when an employer alleges cause, they don't have it. They don't have the goods to prove cause. It's very, very difficult to do that. So don't take your employer's word for it. Gather the information, ask the questions, and then let's talk.
4th thing you need to do if you've lost your job is apply for EI. And the next question is always, do I do it right away after severance? How do I navigate that?
Right away. Right. So as soon as you lose your job, as soon as you're able to apply for EI, there are situations where if you wait too long, you may get denied EI benefits, okay? So apply for EI right away. Now, when you get severance, it's possible that EI won't start paying you until later, until severance runs out, but you still have to apply for it right away. So don't delay, apply, because these are benefits that you're owed. You don't want to lose them.
5th and final thing you need to do if you've lost your job immediately. In fact, this one could have been number 1, and that is talk to an employment lawyer. An employment lawyer, not your real estate lawyer or anybody else. Talk to that employment lawyer.
Hey, guess what? I'm an employment lawyer, but I'll say this, I've said this before. You don't like me, no problem. Speak to another employment lawyer, but you absolutely must speak with an employment lawyer if you lost your job. Chances are, whatever you think of your employer, whatever you think of your situation or your entitlements, that you're owed more than you realize. It's almost always the case. I don't want anyone walking away from their rights. These are legal rights that you have. If you walk away from them, that's going to be a huge shame. So let's talk about it. Let's assess what you're owed. Let's assess if what your employer did is legal and make sure that we pursue the matter the right way.
We're going to take a break, and when we come back, we're going to use another free resource for you, terminationquestions.com. You can use that anytime. We'll get to one of those questions on the other side as we continue more of the employment law show. Stay right there. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show continues. I did mention on the before the break that there's another resource for you to use anytime called terminationquestions.com. You can ask your questions there. Combine that with the phone call to Lior and his team, 1-855-821-5900, and the email, help@employmentlawyer.ca. But, Lior, for this week, terminationquestions.com, here we go. It says, guys, I've been working for 15 years in a supervisor role with no employment contract. I was recently placed on a temporary layoff for almost 6 months, which then became permanent. They offered me 28 weeks. Do you think that is sufficient? Does the long layoff factor into this? I'm almost 50.
So, John, let's start with this temporary layoff before we even talk about the 28 weeks that they offered him. So he could have potentially considered that layoff 6 months earlier as a termination. For most cases and for most people, you don't have to accept a temporary layoff. It's something your employer is not allowed to do. So if you're put on a temporary layoff, you can, of course, sit at home and wait and see what happens. Or you can treat that as a termination and force and get your severance right now. So right off the bat, he could have done that. In this case, he waited, and ultimately the employer did not bring him back, terminated his employment formally, and offered him 28 weeks of severance. So what we need to assess then, well, is 28 weeks of severance appropriate? As I did before, spoiler alert, not appropriate, not even close. But also, as we did before, I want us to go back to the severance calculator tool. Let me show you how you can find out how much you're owed and how, in this case, we can assess entitlements. So we're going to go back to pocketemploymentlawyer.ca, use that severance calculator, and let's see what we actually get. So after 15 years of service, at the age of 49, this person was let go and offered 28 weeks pay. That's 6.5 months. Well, we see he's actually owed 16 months, 1/6. So not 6.5, but 16. That's how important it is to use that severance calculator, John. Again, pocketemploymentlawyer.ca. If this guy was offered 6.5 months and accepted it, guess what? He'd be out of luck. He would be stuck, even though he was owed another year's pay on top of that potentially. Do the right thing, pocketemploymentlawyer.ca.
Next question we got, Lior, comes from the live stream, which you host and some of your lawyers do as well. Facebook, YouTube, and LinkedIn want to join in at ST Lawyers to do so. It says, after 10 years, my manager suddenly put me on a performance plan. I seemingly failed this plan, and I was called into the office and told I'd be let go for cause or I could resign. I contended that there are many errors, discrimination, and wrongful intent on the PIP plan. Do I have grounds to ask for compensation?
So let me look at this from the employer's best case scenario, okay? And that is that the employee was put on a performance improvement plan for good reason and failed at a performance improvement plan for good reason. So that's the employer's best case scenario. That still does not allow the company to terminate for cause, okay? They want to terminate, they would have to terminate without cause with full severance. And after 10 years, this guy could be owed a year's pay. The reason for that, it is difficult to terminate for cause. And the fact that your performance is lacking does not mean that you deserve the worst penalty, which is a termination for cause. If your employer wants you gone, they'd have to pay in the vast majority of cases. But of course, taking a step back, if the performance improvement plan itself was not accurate, was not appropriate, not reasonable, maybe they set targets that didn't make sense, they were really kind of setting them up for failure. What I would have wanted him to do is say so to his employer. If you're put on a performance improvement plan and number one, you don't agree with it, or number two, you don't think it's fair in the way it's set up, I want you to say so in writing. By doing that, you're going to make it much harder for the company to rely on that performance improvement plan as grounds to let you go. If you say nothing, it's as if you've accepted it. So if you don't agree with it, put it in writing, say so. You're protecting yourself, you're protecting your job. Always, though, if you're let go in any of those situations, we need to talk right away.
Am I kind of right to assume in this situation, we've seen this before, where you get a 10-year employee, all of a sudden now they're not doing well, now they need to be put on a performance improvement plan? Is it the first step to kicking them out the door? Maybe?
Yeah, it's usually a way for an employer to try to say, well, we want to let this 10-year employee go, but we know it's going to be a lot of severance, it's going to be a year's pay, maybe more. How do we do that? Let's put them on a performance improvement plan and say performance was lacking, and then just let them go for cause. Well, fortunately, the law is smarter than that. We're smarter than that. It does not work unless the employee is awful and essentially is sabotaging things deliberately. Very difficult to try to avoid paying severance. Doesn't mean your employer won't try, but if they do, call me.
And we're going to get to the fun part of the show to wrap it up here in a couple of minutes, called Employment Law Rapid Fire. Let's do that now. Lior's in the hot seat. Okay, employment rights rapid fire. I ask, he answers. It is just that simple. Number one, Lior, can an employer place an employee in a new position without their consent? Good or bad, I guess, right?
Good or bad. The answer generally is they can, as long as it's not a major change to the terms of employment. So if you're a machine operator and now instead of operating machine A, you're operating machine B, potentially they could get away with that. But could they demote you? Could they put you in a very different position without your consent? No. That could be a constructive dismissal.
Even if they don't change your pay?
Even if they don't change your pay, could easily be a constructive dismissal.
Rapid fire question number two, can an employer relocate an employee to a new workplace?
Very similar to what I said earlier. It really does depend on the change, the nature of the change. If it's a minor relocation, it's across the street, yeah, they can do that. If it's a significant one, maybe it's an hour or more away, no, that's a constructive dismissal. That hour threshold in terms of now it's an hour further, that's the one I use. If your employer is relocating you more than an hour away, again, constructive dismissal.
So time, not distance.
Time, not distance, not kilometers. How is this going to affect you by way of time?
Rapid fire number three, Lior, can an employer deny a medical accommodation?
Generally, no. An employer in most cases must accommodate a medical requirement if you have a doctor's note. It's a very high bar. If they've tried and it's impossible, it's so over the top, maybe then they can deny it. Very rare. In the vast majority of cases, your employer has to follow the accommodation that your doctor has outlined.
Our next employment rights rapid fire is a good one. We get this one a lot, and that is, can an employer ask an employee to reimburse them for education or training expenses? Because sometimes they're mandatory, right?
So they can, as long as there was an agreement in place in advance that that's what's going to happen. If you sign an agreement saying you're going to go through this training, but you're going to pay for the expenses, the materials, then they can ask for that reimbursement. If there was no agreement and now they want you to pay them back, that they cannot do. That's changing the deal. Illegal.
Does it matter if the employee initiated it?
Does not matter.
Wow.
Does not matter. It would have to be a deal that the employer reached in advance, that the employee is going to pay for it. If not, no way.
And finally, can an employer prevent an employee from resigning?
No, absolutely not. Imagine, sorry, we locked you in a room, you're not leaving.
You're not getting out.
No. You can resign whenever you want. Now, it's a question of how much notice you're required to give. Your employer may get upset if you don't give enough notice, and we can talk about that. You cannot be stopped or prevented from resigning anytime and for any reason.
He nailed all five, and he does it every week, seemingly. So there you go. We're going to wrap it up here for now. Always reach out to Lior and the team. The phone call first, 1-855-821-5900. Follow that up with the email, help@employmentlawyer.ca. And you saw us use the severance calculator twice during the show and refer to it many times. That can be found free, anonymously at pocketemploymentlawyer.ca. We will catch you next time in the Employment Law Show. Thank you so much for tuning in, and we'll catch you next time.